Well, I'm very happy to welcome you to Arusha and to the African Institute of International Law. I don't know whether any of you have ever participated before in the courses, training courses or seminars of the African Institute. But it is always heartwarming to see African professionals, lawyers coming together to discuss, to exchange, and to prepare, perhaps, to a certain extent, the future of African integration and Pan-Africanism. Because all these training courses are about building and constructing and making Pan-Africanism a reality. And that is actually the mission of the Institute. But we have to understand, first of all, that we cannot build and we cannot realize and we cannot concretize Pan-Africanism without the rules of law. And I think that is the message that's lost on African political leadership. They think that politically, if they politically pronounce the slogan is about Pan-Africanism, or if they try to talk about Pan-Africanism or put together instruments which are never implemented, then they can somehow, by magic, concretize a Pan-African organization or Pan-African organizations. No, organizations have to be based, they have to be built on rule of law. And that's why I'm happy that you are here, because I think that you can learn about the fact that Africa is going in the wrong way about its economic integration. It's going in the wrong way about building organizations which can contribute to the development of trade among African countries and to the unification of its trade rules. It is going the wrong way about constructing Pan-Africanism. And therefore, we need to correct the way things are going, and the best way to correct it is to bring it back to the rule of law. And I will give you a number of examples why I say that. Because I think they have moved away, or sometimes one actually should ask oneself whether most of the instruments, and we will go perhaps through some of these instruments this morning, whether most of the instruments were ever written by lawyers or legal experts, or whether they are just things that are put there out without any thinking. Because heads of state, foreign ministers come together in the African Union, they adopt the instruments, they forget about them. And then 5 years later, they come together, they adopt another instrument, they forgot about the one they adopted 5 years ago, and they say that they are constructing Pan-Africanism. And they never refer back to the one that they adopted 5 years ago. What's the point of adopting a new instrument when you have totally forgotten about the one you adopted 5 years ago, you never implemented it, you never refer it back to it? And what's the relationship between the two instruments when you claim that both of them, the objective of both of them, is actually to lead to economic integration among African states? How can they lead to economic integration if the instruments themselves are not integrated? So this is the basic message that I want to convey to you today, and I want it to stay with you until the end of this seminar, because I'm not going to stay with you, but you will have a lot of lecturers, and I hope that you can discuss with those lecturers the relationship between 5, 6, 7, I will tell you about them very briefly today, and I will give you a bird's eye view of these instruments which have been adopted by the African Union and before it, the Organization of African Unity, to build, to lead to economic integration among African countries. But they are disparate instruments that are not integrated amongst themselves, that do not refer to each other, that do not have any relationship with each other, including the foundational instruments which are the Charter of the Organization of African Unity and the constitutive instrument of the African Union, which were meant to lead the way and which were meant to inspire and to lay the foundation for all the other instruments. But they don't. So I hope that through training courses, through training seminars, through workshops at the African Institute of International Law, we will be able to build a kind of a coordinated, singular view or vision, I would say, of how Pan-Africanism should legally be built, constructed, and brought in an integral manner together, so that we do not just talk about Pan-Africanism, but we actually anchor it on concrete legal instruments which can be implemented. Because what we have today cannot realistically be implemented, maybe one by one. But they contradict each other, and I will come back to that. But before actually diving into my inaugural lecture, and after having given this kind of a preface and message, I would like to get to know you and to know who you are and where do you come from. I assume that most of you are lawyers. I hope that you are also involved in work on trade or economic integration. There are 8 economic integration schemes, or what are called regional economic communities, regional trade arrangements in Africa, which are recognized by the African Union. 8 are recognized. But the 8 have their own children. They have babies. Each one of them has a baby, and each one of them overlaps with the others, you know. Tanzania is a member of the East African community. It's also a member of SADC. Do the obligations of Tanzania under the East African, are the obligations of Tanzania under the East African community instruments always consistent with its obligations under SADC and its obligations towards other members of SADC? These are the kind of questions that you will have to ask yourself, because Tanzania is only a member of 2 regional arrangements, but there are many African countries that are actually parties to 3 regional arrangements. SADC, COMESA, East African community, many of them. So have they ever given some thought to being legally parties to 3 treaties which may not necessarily be consistent with each other, and where the obligations laid down by these treaties may actually be contrary in certain aspects to each other, and where the level of integration among the member states is different, because one of them may still be at the free trade area level, the other one may have moved it to a customs union, and the third one may actually be at a common market level. So how do you reconcile that? You are together with some states at as a common market, you are together with others in a customs union, and you are together with a third group in a free trade area. How do you reconcile it? Are your obligations really consistent with each other? That's the reason why I was saying, I hope that you are lawyers, most of you are lawyers and trade experts, because we really, really need to correct and to remedy these problems in order to be able to build the economic integration of African states. You know, the economic integration of African states is actually led by a vision called Agenda 2063, which was adopted in 2003 by the African Union. It's good they adopted it so far away, 60 years, because I think that they were actually for the first time realistic, that they will not be able to achieve much in the next 20 or 30 years. But if you really want to achieve progress, if you really want to achieve development, your goal should not be 60 years ago, 60 years away, because it doesn't make sense. Very few human beings actually live up to 60 years. The African Institute of International Law, I hope that you will exchange addresses and you will keep in touch with each other, and that you will also become part of the alumni of the African Institute of International Law, because we need to build a corpus of alumni of the Institute who can also contribute to the advancement of the Institute itself. You should not come here, just have lectures and training course, etc., and then forget about the Institute and go back home. You should develop your relations with the Institute, and you should contribute to the development of the Institute itself. So I hope that you will keep in touch with the Institute, you will leave your address with the Institute, you will inform the Institute of your career development, of your professional development, of where you are, whatever you are doing, so that the Institute also can keep in touch with you, and you are part of this community, and it is really a great pleasure to welcome you to the community of the Institute. The Institute has been now working and organizing training courses since 2015, so for 11 years now, and each year 3 or 4 training courses, specialized training courses, are organized by the Institute, and there are at least 30, 35, sometimes 50 participants. So there is a very, very large community of attendees, of participants of the training courses of the Institute, and we hope that we can build all these attendees into an integrated community of alumni of the Institute who can also give back to the Institute, because the main reason why I personally also have invested so much effort, energy, and time in the founding of the Institute, in the work of the Institute, in the activities of the Institute, is to give back. Give back to my continent, give back to my people. I have had most of my career and have lived almost 50 years in Europe and in the United States. I have not been living in Africa. I have not had a career in African countries, although I am from Somalia. I left at a very young age when I was a young lecturer at the university in Mogadishu in international law. But since then, I have been working, teaching, and lately adjudicating as a judge at the International Court of Justice. And I thought that I could not have done all these things in my life if it was not for the opportunities I received as a young person in Africa. And therefore, I should give back something to my continent. And since my profession is in international law and I am an international lawyer, the best way I can contribute is through international law, through helping, assisting, teaching, and forming the new generation of international lawyers, and of course, updating those who are already international lawyers, but who need to develop their career, or actually who need to know more about their profession. Because we can always learn more. And I'm still learning also, and I'm quite sure that I can also learn from you. But we all need to learn from each other. We all need to contribute to the development of each other. So that is about the Institute. Now let me come back to Pan-Africanism and to the integration of African states. First of all, Pan-Africanism is not actually an idea which was generated in the African continent itself. It was conceived and developed outside the continent, but by Africanists who were taken against the will of their parents, of their grandparents, of their ancestors from Africa. They were diaspora Africanists who still identified themselves with the continent, who still felt that they came from Africa, but they did not even know which part, which African country they came from. They were in the Caribbean, they were in the United States, they were their ancestors were part of the Atlantic slave trade. And that slave trade and the African is taken from the continent. That is a history that is still affecting the condition of the African continent and the progress and development of the African continent. Because hundreds of thousands of young Africans were taken away from the continent and enslaved and treated as commodity in order to contribute to the development of other countries. And their contribution to the development of those countries and to the economic development of those countries has never been recognized. And that is why they decided, at least some of them, those who had the education, those who had the means, that they should come together. They should organize themselves, and they should start a Pan-African movement. And they started that Pan-African movement at the turn of the century in 1905 in London. And that was where the first Congress, Pan-Africanist Congress, was organized. Most of the participants were from the Caribbean, from the UK, and from the United States. At that time, there was hardly anyone who came from Africa. The African students studying in the United Kingdom joined the Pan-African movement later, in the 1920s and in the 1930s, to the extent that when in 1935, a Pan-African Congress was organized in Manchester, again in the United Kingdom, there were some students who later became leaders, political leaders in African countries. And this included Jomo Kenyatta of Kenya, Kwame Nkrumah of Ghana, and Dr. Banda of Malawi. And these are the people who brought, in a way, they repatriated the concept and the ideology of Pan-Africanism and brought it back to the continent. Those who were studying in Europe at the time, who met the original Pan-Africanists from the Caribbean and the United States, who were affected and impacted by this ideology of Pan-Africanism, of bringing Africanists and people of African origin together so that they could improve their lot. That was the basic ideology. We have been subjected to chattel slavery, not slavery only, but to chattel slavery. We have been colonized. We have been compelled to forget about our history, our identity, our culture, and our even statehood, because African kingdoms, African empires, which existed before colonialism, were totally cancelled and removed from the face of the earth, because the Africans were told that they did not have sovereign status, and that under the law of nations of Europe in the 19th century and 18th century, none of the political entities in Africa qualified to be considered a state. So statehood as such was denied to the Africans, in spite of the fact that states existed in Africa. And that is why the Institute has taken the initiative of one of its research projects to look into the history of the pre-colonial international law of Africa, pre-colonial international law of Africa. If you ask a European international lawyer or an American international lawyer about international law in Africa before colonization, they will tell you nothing of the sort ever existed. Because they were taught, it's not their fault, but they were taught in their schools that states and interstate relations based on law or on treaties did not exist in Africa before colonialism, which is totally false, totally wrong. And the first book on the pre-colonial international legal history of Africa is going to be published this year as a result of this research project of the African Institute of International Law. It will be published by Oxford University Press. So please keep your eye on that so that you can learn about the international, pre-colonial international legal history of Africa. So Pan-Africanism was meant to recreate Africa. Unfortunately, the realities were different from the realities which existed before colonialism, because everything was radically transformed. Peoples were taken and joined to other peoples. Nations were taken and joined to other nations and put into a territory fenced by a colonial power. They were no longer referred to as nations, as peoples, but as tribes, which was at the time a pejorative word in European languages, because you will never hear the British referring to the Scottish as tribe. You will never hear the British referring to the Welsh as a tribe. You will never hear the British referring to the Irish as a tribe, but they will refer to African nations as tribes, because a tribe is supposed to be backward. And these African peoples were therefore backward, and therefore they could not qualify as nations. They could not even qualify in the eyes of the colonial powers as ethnic groups. Because Ethiopia, for example, has recognized it in its constitution that Ethiopia is composed of different peoples and nations. Almost all African states, except a few homogeneous states, are actually composed of peoples and nations, which were put together by the colonial powers and which have to recreate themselves now as new nations at the time of independence. And that is why, instead of actually fencing the African peoples and nations in borders which they did not create themselves, but which were created by colonialism, the idea of the Pan-Africanists was to transcend these fences and to bring Africa together. And the leader of that movement was Kwame Nkrumah. But this was, of course, something which did not agree with the schemes, with the vision of the former colonial powers. They did not want a united Africa. So at every stage of the march towards Pan-Africanism, they tried to create blocks and impediments and obstacles. And of course, since the African nations which emerged from colonialism were mostly fragmented nations. They were small nations. They were nations composed of 5 million, 10 million, 11 million people. They were not the large African nations which existed before colonialism. They could easily influence these weak nations, which actually depended to a large extent on their former colonial powers and which traded with those former colonial powers, because a dependence was created by the colonial powers. Relations of dependence, especially economic dependence, was created by the colonial powers before giving independence to the African states, so that these new states, which were different from those who existed before colonialism, would be linked to the European colonial powers and would trade with the European colonial powers instead of trading amongst themselves. And that is what African states have been trying through the promotion of Pan-Africanism to overcome. They have been trying to overcome the state to which they were reduced by colonialism, to be dependent on colonial countries, and to be to export commodities, to be commodity producers, and to provide and supply those commodities to the former colonial powers and import manufactured goods from the colonial powers. So you have to be aware of the historical context in which the integration or the Pan-Africanism has been conceived. Because this is the historical context. And it is to overcome these difficulties, these obstacles, that the African countries tried to create an economic integration. But there were always the colonial powers amongst them. And the colonial powers did not want a unified African continent. So many of the African leaders argued for starting the integration at the sub-regional level. There's nothing wrong with that. Okay, let's start at the sub-regional level. Because maybe it is too ambitious to do it at the continental level. Because Africa was fragmented, Africa was divided, the markets of many African countries were too small, and therefore we have to develop at the regional level, at the sub-regional level, and then maybe integrate the continent as a whole. And that is how the first regional free trade agreements and the first regional economic communities were created. But they were created, as I said earlier, on emotional and political basis, without actually thinking through legally on how best this type of organizations could be created. You know, in Europe, they started with the iron and steel community, and then they progressed slowly so that they could co-opt other European countries, but they established certain legal conditions and criteria for joining, economic and legal conditions, for joining the community so that the community can develop and can develop on the basis of common values. Why do I say that? Because, you know, unless you establish common values and common goals, and unless you start from those common values and criteria which you have all agreed upon, you will not be able to progress. Because instead of starting from basic criteria to which each one of you subscribes, people will come with their own criteria and will, of course, spoil actually and create impediments to the progressive development of the integration. And that is what has happened in most African countries. So the regional, sub-regional communities were not based on legal criteria and economic criteria. Nobody told the members that you have to fulfill this criteria, not geographical criteria. No, you are of course in East Africa, but it's not only geographical criteria, because on the basis of geographical criteria that we are going to build our regional integration. We have to build our regional integration on economic and legal criteria. So the East African community was created. The East African community was doing well, but the East African community did not establish common criteria and common values. So you have Uganda, which had a dictator called Idi Amin, and he wrecked the East African community. The East African community was totally destabilized. So the East African community itself actually disappeared for a while because of that situation. And there was a war between Tanzania and Uganda. And so it is because there were no common criteria. There was no common values on which the integration was built. Because otherwise, the East African countries should have said from the first day that Idi Amin came to power through a coup d'etat, Idi Amin, Uganda, stay out. You cannot be part of the East African community because you do not have certain economic, political, you do not correspond anymore to the economic, political, and legal criteria which member states have to fulfill. Because you cannot just have a free-for-all integration. It's not possible. And then, of course, since such criteria did not exist, African member states of one regional group could join other regional groups. You know, Colonel Gaddafi of Libya came up with an idea of what he called it CENSAD, Regional Economic Community. CENSAD is not a regional economic community. It is a trans-regional economic community. It has member states from all over Africa, from East Africa, from West Africa, from North Africa, and from South Africa. But it was a construct, an integration group that was created by Gaddafi, and he just invited states to join them. And up to now, CENSAD exists on paper. Maybe it meets occasionally, but CENSAD does not really correspond to any reality. It was a totally political and emotional integration group, regional integration group. It includes the Sahel states, and it includes East African states, and it includes West African states, and it includes North African states. So how is it a sub-regional or a regional economic community? Even it does not qualify under the regional economic communities as defined by the Abuja Treaty. But the problem is that African leaders cannot tell each other the truth, and therefore they cannot say CENSAD doesn't exist for us as a regional community. Please, if you want to have a political grouping called in CENSAD, have it. And you can have your political relationships, etc., but you are not a regional economic community as a building block for the continental economic community which the Abuja Treaty was supposed to promote, because the Abuja Treaty was concluded so that it could coordinate as building blocks the regional economic communities, and a continental community could therefore emerge from that. So, we come from the Nkrumah Pan-Africanist dream. It doesn't work for many African states. So we go to the sub-regional integration, and we say that we are going to build regional economic integration groupings, East Africa, Southern Africa. The Southern Africa Development Cooperation Conference was turned into the Southern Africa Development Cooperation Organization, SADC. And then ECOWAS was created in West Africa, but there is something smaller under ECOWAS, which I referred earlier to, as the babies of the regional economic integration groups, which is called UEMOA in French, Union Économique et Monétaire West Africaine, Union of Economic, Monetary and Economic Monetary Union of West African States. It is part of ECOWAS, but it is actually more advanced in its integration than ECOWAS, because it has a monetary union based on the colonial relationship with France. And they all use the CFA, franc, as the common money in these countries. So it has that. And then there is the Economic Community of Central African States, ECAS. ECAS also has a baby called the Economic and Monetary Union of Central African States, which have a more integrated relationship amongst themselves. Then we have SADC, and SADC is for all the Southern African states, but SADC also has a baby, call it the Southern African Customs Union, which is a customs union, because SADC is still a free trade area. But a customs union has been created by 5 states within the SADC. And Eswatini, Botswana, Namibia are members of that customs union. And actually in the Abuja Treaty, an exception was made for the Southern African Customs Union. And that was really one of the treaties which referred to an existing reality as far as economic integration is concerned. Because most of the treaties in Africa do not refer, or protocols of treaties do not refer to the preceding protocols or the preceding treaties, and do not refer also to treaties existing in the continent, although they are supposed to be continent-wide treaties, which may be inconsistent with the provisions of that treaty. They do not. They do not even care about it. And you feel as though these treaties were actually elaborated in different planets and in different continents, that they were not elaborated and conceived by the same people under the umbrella of the Organization of African Unity or the African Union. So it is optional. Wherever you are in Africa, you can join any regional economic community. There is COMESA, and under COMESA there is the East African Community. Under SADC also, because some of the East African communities are part of SADC. So under SADC you also have the East African Community, and then some members of the East African Community are part of the Economic Community of Central African States. You have all this overlapping membership. And then in COMESA, you have Egypt and Tunisia. COMESA was created for the common market of East and Southern. That's the name of COMESA. Common market, although it's not a common market, it's a free trade area. But it's called the Common Market for East and Southern African States, Southern Africa. But Egypt is a member, Tunisia is a member. So how do you justify that? What are the legal bases? What are the economic criteria? It's a free-for-all. It is political criteria. It is emotional criteria. Oh, the president of that country approached us, let us admit them. Let's make them a member of the... and I'm quite sure that maybe the reason why Gaddafi decided to create Sensia is because he was not admitted, Libya was not admitted perhaps to COMESA or to SADC. So he said, I will create my own regional group. And he created Sensa. So they are not based on economic realities. They are not based on economic criteria. and they are not even based on regional criteria. And that is really where the problem lies. So, what happened then? The regional, sub-regional economic communities were created with all these contradictions, all inconsistencies, all these problems, and of course, African leaders and African intellectuals, scholars realized that this could not actually work. So they said that we have to adopt a treaty in 1991, which would bring together all these regional economic communities and use them as a building block for a wider African economic community. And that was the objective of the Abuja Treaty. The African Economic Community, it's called the African Economic Community. It is a continent-wide economic community. And it was meant to promote liberalization. It was meant to promote economic integration. It was meant to promote economic development. It was meant to promote Pan-Africanism in the economic field, But not only in the economic field, because you know what happened? You look at the African Economic Community and the Abuja Treaty. The Abuja Treaty is the treaty which created the Pan-African Parliament. Because the African leaders decided, well, we need to have a parliament, a Pan-African parliament, like the Europeans have a parliament, let's have a Pan-African parliament. And at the time, the OAU had no provision for a Pan-African parliament. So they decided to put it in the Abuja Treaty. And then they wanted to create an Economic and Social Commission, a kind of a UN ECOSOC for Africa. And then they said, let us create the commission under the Abuja Treaty. And therefore the ECOSOC, African ECOSOC, was also included in the Abuja Treaty. And then they said, let's create an African Court of Justice, because the OAU instrument does not have a Court of Justice. And then they put an African Court of Justice under the Abuja Treaty, the African Economic Community. Well, it's good to have a Court of Justice for an economic community for the entire, of course, continent, because if you have an economic community for the entire continent, disputes are bound to arise among the member states, and it is good to have a dispute settlement mechanism. And of course, even the sub-regional economic communities have their Court of Justice. The ECOWAS has the ECOWAS Court of Justice. The East African Community Court of Justice is here in Arusha. The SADC has a Court of Justice. I think it's called the SADC Tribunal, not Court of Justice, but Tribunal. And the COMESA has a Court of Justice, which is based in Sudan, in Khartoum, but which has never been used by anyone for any disputes. The East African Community Court functions, the ECOWAS functions, the SADC, it functions, it does not function because of a case that was brought by Zimbabwean settlers, and in which it actually ruled in favor of the compensation of the settlers, and Mugabe got angry and said, this is not a tribunal, this is not a court of justice, it is there to compensate white people, let's get rid of it. And they got rid of it, they suspended it for a while, but then they rewrote the charter and they brought it back in a kind of a different tribunal, and since then, it's not what it used to be. So there are courts of justice even at the regional economic communities, but they do not function that well. They do not work. You know, I think that legal or dispute settlement based on the law is not very popular in Africa. Governments want to settle disputes politically. They don't want to settle disputes legally. And therefore, even if you create, you know, the East African Community Court of Justice is one of the most successful. The ECOWAS is also rather quite successful, I should say, to a certain extent. But neither of them actually is successful with respect to the real mission for which it was constituted, which was disputes between the member states regarding the economic community itself and the disputes on the interpretation and application of the treaty establishing the economic community. They are active on human rights, you know, on a kind of tangential, peripheral issues which are not central to the economic integration between the member states. Because the member states themselves prefer to settle that through direct bilateral negotiations between the heads of state and between the governments. They do not want to submit it to a court of law. They are kind of allergic to courts of law. They don't want this to be decided by law. They want it to be decided, you know, over a cup of coffee between leaders, politically and through compromise. Not bad if you can do it, but there was no point then to pay the salaries and to keep an institution of 10, 15 judges there without actually giving it the mission or the tools for the mission for which it was created. It's totally useless. So these regional, sub-regional economic communities existed. The Abuja Treaty was created, and the Abuja Treaty started coordinating. And the Abuja Treaty contained, and you will come to, and I will very briefly come also to the African Continental Free Trade Area, but of course others will lecture on that, but I wanted to set the background and the context in which the African Continental Free Trade Area, from which it emerged, the historical context from which it emerged. So the African Economic Community was actually supposed to do most of what you see in the African Continental Free Trade Area. Liberalization of trading goods, liberalization of even movement of persons. And it was meant to do that through its building blocks, which were the sub-regional economic integration groupings, and to coordinate them and to harmonize their work and their activities. And this was the basic objective, the basic rules underlying the Treaty of Abuja. The Treaty of Abuja was concluded in 1991. It had a secretariat, it had institutions, the Assembly of Heads of State of the Organization of African Unity was the main governing body, then the ministries of trade, etc., and then the senior trade officials, like the African Continental Trade Agreement. But then the African countries decided to do away with the Organization of African Unity and create the African Union. So this was a new stage in the political construction of Pan-Africanism. But was it a new stage also in the economic construction of Pan-Africanism? I'm not sure, because it's not really very clear. And I don't think that the African leaders who created the African Union gave much thought to it, because they neither decided to do away with the African Economic Community nor to keep it. Because you have to be very clear. Does the African Economic Community continue to exist, or is it completely eliminated? Is it put aside? The African Union did not want to say that. They did not even want to say much about the relationship between the African Union Constitutive Act and the Abuja Treaty. So what the African Union Constitutive Act says in Article 33(2) is that the provisions of this act shall take precedence over and supersede any inconsistent or contrary provisions of the treaty establishing the African Economic Community. How do you understand that? Which provisions are inconsistent or contrary to those of the African Union? Which provisions of the Abuja Treaty? Has anybody studied that? Has anybody ever prepared a list of the provisions which could be contrary or inconsistent with the African Union Constitutive Act? And what is exactly the relationship between the two instruments? Nobody cares about it. But practically, if you look at it, the Abuja Treaty was set aside. But at the same time, it continues to be used by the African Union whenever it is useful to use it. I'll give you some examples. It was set aside because of this, although this was never elaborated upon. It was never elaborated upon. But, for example, the Abuja Treaty established the Pan-African Parliament. So the African Union did not want to lose the Pan-African Parliament together with the Abuja Treaty, because in their minds, actually, they got rid of the Abuja Treaty, although they never said it clearly. But they wanted to save the Pan-African Parliament. So the African Union enacted a protocol on the Pan-African Parliament. And that protocol says, and that is really very interesting, so Article 2 of the protocol, which was enacted by the African Union, says that the Pan-African Parliament is continued in existence and shall have the functions and powers provided for in the present protocol. And that is in 2001, the same year in which the African Union is created. So the Pan-African Parliament is taken from the Abuja Treaty and is now given existence under a protocol that is adopted by the African Union. What is exactly the relationship between the protocol and the African Economic Community Treaty? Nobody says that. And therefore you ask yourself, are these things written by lawyers, or are they written by just a group of politicians who meet in a room and they just decide to put this on paper? You really ask yourself. Because in 2018, Because, of course, that clearly indicates in a way that the African Union decided to get rid of the African Economic Community. If you take out from that treaty the Pan-African Parliament, and you have a new protocol on the Pan-African Parliament which says the Pan-African Parliament continues to exist, it means that the treaty which gave birth to it in the first instance no longer exists, and therefore persons. Because if you say, I'm going to liberalize goods, movement of goods, I'm going to liberalize movement of services and trade in services, I'm going to liberalize investment, I'm going to adopt all these kind of things, how are you going to encourage, promote all of that, especially services, digital trade, and liberalization of goods without a free movement of persons? And actually, the African Continental Free Trade Area says that it is one of its objectives to promote and to encourage and to actually provide for a free movement of persons in the continent. But it has protocols on liberalization of trading goods. It has a protocol on liberalization of trade in services. It has a protocol on liberalization of digital trade. It has a protocol on all kinds of things, but not on free movement of persons. The protocol on free movement of persons is a protocol to the Abuja Treaty. What kind of legal construction is that? And who ever thought of such an architecture, legal architecture? I mean, how do you justify really such a legal architecture? And worse than that, the African Continental Free Trade Agreement does not even refer, despite the fact that it says that it will provide for free movement of persons and promote free movement of persons, it does not even refer to the protocol on free movement of persons. It doesn't refer to it at all. It is as though there is no protocol under the African Union on free movement of persons. And what is exactly the relationship between the African Continental Free Trade Agreement and the protocol on free movement of persons? Well, the African Continental Free Trade Agreement is very popular with African countries. Very popular, because 46, I don't know, 47 of them have ratified it now out of 54 or 55. And therefore, it is a living legal instrument. But the protocol on the free movement of persons has been ratified only by 5 member states of the African Union. 5. And there is no reference to that protocol in the African Continental Free Trade Area. So what is the relationship between these different instruments? They are all meant, you are told, they are all meant to promote and to provide for economic integration, for the economic development of African countries, but each one on its own. So they have no relationship with each other. And I really pity the judges whose countries are parties to this instrument and who may have to adjudicate on such instruments. We have a number of judges here in commercial divisions. And of course, imagine if this came up also in the courts of justice of the sub-regional economic communities. What would one make of it? And how would one deal with it? Because the relationship even between the economic communities and the AFTA, the African Continental Free Trade Area, is not very clear. You see, the Abuja Treaty was very clear about African sub-regional economic communities, the free trade areas, the customs unions, the common markets, which existed in the African continent. And it was meant to bring it together so that liberalization would take place in a harmonious manner throughout the continent and with all the sub-regional arrangements contributing to it. This was the vision of the African Economic Community. Article 88 of the Abuja Treaty said, and I quote, "The community shall be established mainly through the coordination and harmonization and progressive integration of the activities of regional economic communities." And that, number two, member states undertake to promote the coordination and harmonization of the integration activities of regional economic communities of which they are members with the activities of the community. They undertake to harmonize it with the activities of the community, it being understood that the establishment of the community is the final objective towards which the activities of existing and future regional economic communities shall be geared. This was the Abuja Treaty. And therefore, the relationship between the Abuja Treaty as a liberalizing instrument, as an integration instrument, or economic integration instrument with the sub-regional economic communities was clear. As I said earlier, even the existence of the Southern Africa Customs Union was recognized in the Abuja Treaty. But what does the African Continental Free Trade Area say about the regional economic communities? Because the African Continental Free Trade Area is also meant to liberalize trade throughout the continent, and that is the basic everyday bread and butter of the sub-regional communities, because they are free trade areas, and it's meant to work with them. But it doesn't seem as though it was actually conceived to work with them. But there is a saving clause, and that is the second paragraph of Article 19. And that is actually the only paragraph which has some sort of a constructive approach to the relationship between the AFTA, the African Continental Free Trade Area, and the existing free trade areas in African countries. And the paragraph reads as follows: notwithstanding the provisions of paragraph 1 in this article, state parties that are members of other regional economic communities, regional trading arrangements, and customs union, which have attained amongst themselves higher level of regional integration than under this agreement, shall maintain such higher levels amongst themselves. It means that you are much more advanced than us. We are not as ambitious as you are. We are not a customs union. We are not a common market. The only thing we are doing is free trade area. And therefore, if you are more advanced at the sub-regional level and you have a customs union or you have a common market, please maintain it. Maintain it and continue with it. But it does not say how those customs unions and the obligations of the states members of those customs unions, are they to be treated as an exception, as was the Abuja Treaty for the Southern Africa Customs Union? Are they to be treated as something which actually should not be regulated under the African Continental Free Trade Area because they are much more advanced? It just says, maintain your arrangement, maintain it, because you are more advanced than us. So the kind of legal integration, legal harmonization, which was meant to take place, not taking place. And this will definitely frustrate efforts and frustrate the attainment of the objectives of the African Free Trade, Continental Free Trade Agreement, and of African economic integration in general. It is poor drafting of treaties. It is a poor approach, legal approach to lawmaking. It is a very inconsistent lawmaking and making of treaties, and therefore it may actually contribute to the failure of the integration we are all seeking and the economic development we are all seeking for Africa. Because despite the fact that you create wide frameworks which are not clearly connected to what exists on the ground, because what exists on the ground, and it is a reality which cannot be ignored, are the sub-regional economic community, regional economic communities. And unless you recognize them, and unless you have an approach similar to the Abuja Treaty, whose fate nobody can tell you clearly what has happened to it, then of course it is difficult to achieve the kind of progress that is desired by the African Union, and we will have to see to what extent the AfTA will be able to work together with the regional economic communities, because its future, to a large extent, depends actually on coordination and harmonization with regional economic communities. There are now 8 regional trading arrangements in Africa which are recognized and registered with the World Trade Organization. And AfTA is not yet registered and is not yet considered by the WTO as a free trade area which is part of the WTO. The African countries will have to perhaps see to it that this is done as quickly as possible, because there are now almost 47 countries or 46, I can't remember which one, that are parties to the African Continental Free Trade Area, so they will have to do something about it and register it. But the ones that are registered are the Southern African Customs Union, which is operational. They are registered as customs union, sorry. They are not registered as free trade area. They are registered as customs union. Southern African Customs Union, which is operational. ECOWAS, which is also operational as a customs union. East African Community, which is operational as a customs union and which actually has gone much further even and has a common market. The West African Economic and Monetary Union, WEMOA, which is operational, and the Economic and Monetary Community of Central African States, CEMAC, not ECAS. ECAS is the parent organization. CEMAC is one of the babies of ECAS, and it is a monetary and trade economic union. And then COMESA is also registered, because you know COMESA is still a free trade area, but wanted to establish a customs union since, I think, 2008, and even declared that it is going to establish a customs union, but has not up to now actually succeeded to do that, because I think all the member states of COMESA are not yet on board as far as a customs union is concerned, because with a customs union, you need a common external tariffs, a wall. And unless all the member states agree that you create that wall, that CET, then you cannot have a customs union. And so maybe they have not all agreed, because I told you, it's not based on a regional criteria. It's not based on concrete legal criteria. It is just based on political and emotional decisions, which mean let's get together, we are brothers, we create our own integration scheme in this region, and then others from other regions come. Egypt came, Tunisia came, and do Egypt and Tunisia want an external tariff for all the countries with which they trade? By COMESA, I'm not sure. Do all the members of COMESA itself want? That's why a customs union could not be realized in COMESA, but it is still considers itself as working towards a customs union. And as far as the economic integration schemes in regional economic communities are concerned, there are 8 that are now recognized by the African Union. And the funny thing is that in 1998, a protocol on relations between the African Economic Community, which was the Abuja Treaty, and the regional economic communities was signed. And it was signed on behalf of the African Economic Community, not by the Secretary General of the Economic Community, because the Economic Community had a secretariat, like the African Common Continental Free Trade Area has also a secretariat. It wasn't signed by him. It was signed by the Secretary General of the Organization of African Unity, Salim Ahmed Salim at the time, 1998. And the OAU, the African Economic Community, signed that protocol of relations between the African Economic Community with the 6 regional economic communities, which were COMESA, SADC, IGAD, ECOWAS, ECAS, Economic Community of Central African States, and the Arab Maghreb Union, which actually knows whether it is operational or not, because there are so many problems between Algeria and Morocco that the Arab Maghreb Union is on paper, but it does not really properly function. 10 years later, and this is what creates also the ambiguity about the continued existence for the African Union of the African Economic Community Treaty, of the Abuja Treaty. Because in January 2008, another protocol was signed on relations. This time, the title of the protocol is Protocol on Relations between the African Union and Regional Economic Communities. The earlier one was Protocol on the Relations between the African Economic Community and Regional Economic Communities. But remember, it was signed by the Secretary General of the Organization of African Unity. Now, there is a new protocol in 2008 between the African Union and the Regional Economic Communities, which is signed by the President of the Commission of the African Union with the same regional economic communities, plus CENSAD, which of course came into being after 1998. So this kind of casts a doubt on whether the African Union recognizes that the African Economic Community still exists and that the Abuja Treaty still exists. Because if the Organization of African Unity, the Secretary General, signed an agreement with regional economic communities 10 years earlier, what is the need to sign another protocol with the same economic communities under the African Union? And even if you decide, let's say you decide to have another protocol, which is actually a successor to the earlier protocol and replaces it, then you should say so in the new protocol. You should say that this protocol replaces and supersedes the protocol of 1998. The protocol of 1998 is not even mentioned. No reference. So this is why you ask yourself, who are the people who are writing these things? Who are the people who are drafting this thing? You know? How is it possible that African lawyers, whether they work for the African Union or for the member states, and I hope that you can advise the countries from which you come about the relationship between all these legal instruments. How is it possible that these lawyers do not draw the attention of their governments, of their government officials who participate in these meetings, to the relationship between these instruments, and to the inconsistencies, and to the problems which may arise tomorrow from these inconsistencies, and therefore undermine the implementation and operation of this treaty? Well, I think I have said enough, and as an introductory lecture, and I hope that this a kind of bird's eye view of the construction of the integration of the construction of the economic and political integration of African states serves as an introduction to what you will hear in the coming few days, and give you at least a foretaste and a basis on which you can look at the AfTA from a critical point of view. Because the AfTA is now the latest instrument. It is very popular with African states. Everybody, it is something which is similar, and sometimes you think that people have just copied provisions of the World Trade Organization instruments and put them here. You know, it is a copy-paste from the World Trade Organization. But it is very popular. It has been ratified by so many states. So, of course, your countries are parties to it. You will have to deal with it. You will have to see to it that it is implemented, and it will have to be implemented because it's a legal commitment. It's legally binding. But it has to be implemented, taking into account the possible inconsistencies, possible problems that may exist with preceding instruments, with instruments which may still exist, but whose relationship with the African Continental Free Trade Area has not been clarified, like the Abuja Treaty, and also provisions of the sub-regional economic communities which are meant to build the building blocks of economic integration of African states. Thank you. The sub-regional communities which are meant to build the building blocks of economic